Welcome to Ag Talk, the podcast where we explore the evolving landscape of agriculture, policy, and people. I'm your host, Jennifer, and today we're diving into one of the most talked about topics in South Africa's farming community, the 2025 Expropriation Act, and how white farmers are responding. Our guest today is Dr. Gang, an agronomist from Calc LLC. What is the Expropriation Act of 2025?
Earlier this year, South Africa passed the Expropriation Act of 2025, a law that expands the government's ability to acquire land for public interest, including land reform. It allows for compensation that's not strictly based on market value, and in some cases, even nil compensation. This has sparked a wave of reactions, especially among white farmers, who still own a significant portion of commercial farmland.
Are white farmers concerned?
Yes, many white farmers are deeply concerned. The fear? That their land could be taken without fair compensation. Some worry that this could echo Zimbabwe's land reform crisis, which led to economic turmoil and food insecurity. There's also frustration over the lack of clarity in the law. What exactly qualifies as land eligible for expropriation? The uncertainty makes it hard for farmers to plan for the future. And then there's the international spotlight. U.S. President Donald Trump even weighed in, freezing aid to South Africa and accusing the government of targeting white farmers. While controversial, some farmers welcomed the attention, hoping it might pressure the government to tread carefully.
What are the reactions of white farmers?
But it's not all fear and frustration. Many farmers are choosing resilience. Theo de Jager, president of the Southern African Agri Initiative, says most farmers are committed to staying and farming the land they love. They're not just waiting, they're engaging. Legal groups, civil society, and farming unions are working to ensure the law is implemented fairly and that property rights are respected.
Is it fair for South African farmers?
It's important to remember, land reform in South Africa is about more than just ownership. It's about redressing historical injustices and creating a more equitable future. While white farmers are a vocal part of the conversation, the majority of South African farmers by number are black. The challenge now is finding a path forward that balances justice, food security, and economic stability.
But what about here in the U.S.? Could something like that happen on American soil?
The short answer? No, not under current U.S. law. Here's why. The Fifth Amendment to the U.S. Constitution clearly states that private property can't be taken for public use without just compensation. This principle is the backbone of what we call eminent domain. So yes, the government can take land for things like highways, schools, or public utilities, but they have to pay you fair market value. And if you don't agree with the price, you can take it to court.
What about nil compensation?
Now, in South Africa, the law allows for nil compensation in specific cases, like abandoned land or land held for speculation. But in the U.S., that's a non-starter. Even if a regulation severely limits how you use your land, courts have ruled that compensation may still be required. So, unless there's a constitutional amendment or a radical shift in how the Supreme Court interprets the Fifth Amendment, land expropriation without compensation just isn't on the table.
Could that ever change?
Could it happen someday? Technically, anything's possible. But politically and legally, it would be a massive uphill battle. Property rights are deeply embedded in American law and culture. Any move to change that would face fierce resistance from courts, lawmakers, and the public.
Dr. Gang, thanks a lot for your insight. That's it for today's episode of Ag Talk. If you find this topic thought-provoking, please like it, share it with a friend, and subscribe for more deep dives into the laws that shape our land. Until next time, stay informed and stay grounded.